Good. Would you ask Ms Williams to come back in, please? Thank you. All right, Ms Williams, happy to carry on.
Yes.
Thank you. Yes, Mr Millett?
Yes. Ms Williams, we were in the middle of the topic relating to the principal designer in the late part of 2015. Can we go next, please, to ART 409336? And this is an email from Neil Reid to Burrows on the 3rd of September, and also to Simon Cash. Claire will be appointing the COW organisation, JRP, who tells me all their CDMCs are simply becoming PDs, and they see no issue with this transition. I understand other organisations are exercising the same approach. I do think it courteous for one of you to phone Claire and discuss the handover of the role from us to their appointed PD. You see that?
Yes.
Did you consider JRP, John Rowan Partnership, as a potential CDMC?
I don't remember considering them at the time.
Right. Do you know how Neil Reid would have formed the impression that JRP was available to be appointed as a CDMC?
He would have spoken to our clerk of works, who would have mentioned it.
So when he says Claire will be appointing the CWO organisation, clerk of works organisation, did that come from you or from JRP, do you think?
Oh, I see what you mean. I don't know. I don't remember talking about JRP as a CDMC.
Right.
I'm not sure of the phraseology there.
Right. My question at line 17 was wrong. I should have asked you, how did Neil Reid form the impression that JRP, John Rowan Partnership, was available to be appointed as a principal designer, PD? So what is the answer to that question? Do you know?
I believe he would have spoken to our clerk of works, who would have mentioned it.
Right. Given that you were anxious at this time to have someone internal to the project with some experience on the project, why didn't you ask John Rowan Partnership whether they would act as principal designer?
I think it's clear from my testimony that there was quite a lot of confusion about the role at the time, in that initially I thought Atelier were taking it on. Then it transpired they weren't, and they suggested that I speak to Ryden, Studio E, and when both of those parties weren't available, then obviously I'd spoken to Bailey Garner. So I was being pushed a little bit from pillar to post, and perhaps getting... I should have been getting more specific information to help me appoint.
Given that nobody was prepared to be appointed principal designer who had been involved in the project up to that point, did that indicate to you that it was a substantial undertaking?
No, not at that stage, because the project completion date was nearing, and the role didn't have any design checking at that stage, and it was seemingly more about putting together the health and safety file at the end of the project. So I think I didn't think it was a major role. I thought somebody had mentioned insurances. Somebody had mentioned it was preferable to have somebody who was involved with the scheme from inception. But no, I didn't think it was insurmountable.
If you didn't think it was a major role, didn't you wonder why it was that neither Ryden nor Studio E, who had, of course, been involved in the project since inception, and certainly since the contract, wouldn't take it on?
It seemed to be because of the new role that there were perhaps people hadn't been trained or something of that order, rather than anything more complex.
Well, did you actually investigate why it was that Ryden wouldn't take it on?
No, I didn't.
Did you investigate why Studio E wouldn't take it on?
No, I didn't speak to Studio E. It was all done via Ryden, but I think Ryden said to me that it wasn't something they'd done before because of the new role. So it was, seemingly people were not keen to take it on because it was something they hadn't done before and they weren't geared up for.
But it wasn't something that you'd done before either, was it?
No.
So why were you prepared to take it on where they weren't?
Because when Simon Cash did speak to me, we talked about the stage of the project and that the design was completed, and I think he gave me the expression fundamentally complete. So there would be no design input required, but it would be the role at the end of the scheme, which was compiling the health and safety file.
Did the fact that neither Ryden nor Studio E were prepared to take on the role, nor either JRP, as it seems, indicate to you that it was a task that had significant risk attached to it?
No, as I say, it seemed to me more that because it was a new role, people weren't geared up, they weren't trained, that they didn't have perhaps a department or people in place who could carry out that role.
Right. Can we go to your 20th of January statement, please, at page 4? And I'd like to look at paragraph 19. You say there, "It is my belief that had Artelia, as CDMC and employer's agent, explained the nature of the principal designer role and Artelia's inability to take on the role to the TMO earlier, the TMO would have had more time to consider its options. In reality, the TMO was given short notice to find a principal designer. The appointment was further complicated by the fact that none of the parties involved in the design from inception would take on the role, nor would the external consultant I approached on the basis that it had not been involved since inception." And I think the external consultant there is Bailey Garner. Is that right?
Yes.
Yes. Now, you say short notice there. TMO was given short notice to find a principal designer. By that, do you mean that by the time the 2015 regulations came into force on the 6th of October 2015, you had short notice?
Yes, because I believe it had first been mooted, as we've seen, in July, but it wasn't clear that Artelia weren't going to take the role on. It said TMO need to appoint a principal designer. It didn't say we are not going to be able to do this. It said the TMO needed to appoint a principal designer. So it wasn't clear until perhaps September that they didn't anticipate carrying on with that role.
Right. Why was it not possible for the TMO to appoint somebody after the 6th of October as principal designer?
I believe when I spoke to Simon Cash and we talked about the pros and cons, that what was deemed outstanding was the health and safety file, which the principal contractor was obligated to provide the information for.
Did it occur to you that the TMO could have held the role of principal designer temporarily from the 6th of October until somebody properly skilled with that role came in? That would have been possible, wouldn't it?
It would have, but I say the substantive advice came quite late in the day.
You say the substantive advice came late in the day, or short notice, but in fact, although it was a short period between, let's say, September and the 6th of October, it was possible to extend that period simply by using the expedient of the TMO occupying the role until they did find somebody.
That was never put to me as an option, and I hadn't thought of it.
Right. Can we then go to your 20th of January statement at page 6? So same witness statement, page 6, please, and let's look at paragraph 26 further down. I think we've just looked at that. You say, having reflected on these events, it's my belief that the TMO was let down by its professional team. Sorry, I'm so sorry, we haven't just looked at this. You say, it's my belief that the TMO was let down by its professional team in respect of the appointment of a principal designer. The TMO had appointed Artelia as its CDMC and was entitled to rely on it to advise as to how best to meet its CDM duties, there was an obvious delay in Artelia formally informing the TMO of the need for the principal designer appointment and of its inability to take on the role. Furthermore, it failed to provide the TMO with any solution when Ryden, Studio E and Bailey Garner declined to take on the role, terminating its own appointment without ensuring a principal designer was in place. Now, just unpacking that a little bit, if we can. When you say let down by your professional team, do you mean all of them?
No, I mean Artelia's CDMC team, that there was a gap, and I would have expected them to have given us advance notice and given us proposals as to how to manage.
And in what capacity did you expect them to give that advice? In what capacity under the contract that you had with them did you expect them to give you that advice?
As employer's agent, they would know that we would need to have this appointment in place because it would be essential for the contract.
So you say that that was part of their obligations as an employer's agent, do you?
Yes, to find shortfalls, if there are any shortfalls in the professional appointments, to highlight that to us.
Was that something in your mind at the time, that they had contractual obligations as employer's agent to give you advice about becoming or finding somebody to become a principal designer?
Yes, and we'd had a long-standing relationship with them, so yes, I would expect them to provide professional advice.
Did they know that you were expecting them to do that in their role under the contract as employer's agent?
I believe they were competent employers' agents and would understand that that was one of the areas that they needed to manage.
Now you go on to say in the... Let me just follow that up a little bit. You say that you believe they were competent employers' agents and that they would understand that. Does that tell us that you didn't actually have an express conversation with Artelia, and in particular Artelia in their role as employer's agent, and say, as employer's agent, you are required to advise us as to the appointment of a principal designer? Please do so.
No, I believe it first came out through the email you showed me where Neil Reid sent on an F10.
Yes.
So Neil Reid was aware of the obligation. Sorry, I've lost your question a little.
No, my question was whether there was an express conversation in which you pointed out to them that you were expecting them to comply with a contractual obligation as employer's agent to advise you as to the role of principal designer.
No, there wasn't an express conversation, but the conversation, I believe, started with the F10 that Neil Reid sent to me in July.
Did it occur to you at the time to check the terms of the contract that you had with Artelia, just to make sure in your mind that you were entitled to look to them for that advice?
No, but they were also appointed as CDMC, so I would expect that either of those roles within Artelia could have provided the professional advice
Well,
required.
you've just moved across to CDMC, and I'd asked you, and you said employer's agent, and my question was focused on employer's agent. Let's take it in stages, because you've introduced a new idea. My question one more time, did it occur to you at the time to check the terms of the contract that you had with Artelia to make sure that in your mind you were entitled to look to them for advice? And that was in the context of them acting as employer's agent.
No, I didn't refer to their contract.
No. And what about the parts of the contract which dealt with their obligations as CDMC? Did you look back at the contract to satisfy yourself that they had those obligations under that part of the contract?
No, I didn't, but again, we had a long-standing contract relationship with them. They were managing that contract, and I would be expecting them to make sure that there were no deficiencies.
Now, you say in your statement, excuse me, in the second sentence, that the TMO had appointed Artelia as its CDMC and was entitled to rely on it to advise as to how best to meet its CDM duties. Did you have people within the TMO who were responsible for the TMO's compliance with health and safety law generally?
Yes.
You did. And was that Janice Ray and her team?
Yes.
Yeah. Did you ask Janice Ray's team in-house what you should do in respect of the Grenfell Tower project to comply with the CDM regulations as they now came into force in
No.
October 2015?
No.
Why is that?
Because I had consultants who I felt were competent and should be advising us as a matter of course.
Right. Would you agree that any decision about how the TMO should reach its regulatory obligations was properly a decision in the end for the TMO?
We would have to ultimately decide, but upon advice from those in a best place, yes.
And would you accept that the most that Artelia would do, or were obliged to do, was to advise you as to your options as they now stood in the light of the new 2015 regulations?
Yes, if they'd provided us with options, that would have been a way forward.
You say in the last sentence that that's Artelia, failed to provide the TMO with any solution when Ryden Studio E and Bailey Garner declined to take on the role, etc. Are you saying there, to be clear, that you thought at the time that it was Artelia's role or responsibility to find a solution when the legislation changed?
It was their role to advise us as to how we would need to manage the new regulations.
Yes, I see that's what you thought at the time. Did you think at the time when you wrote this statement that Artelia was supposed to fill this appointment for you?
They were supposed to I would expect them to advise us what the options were.
Yes, but not actually to take on the role.
That they might have taken on the role because, say, I believe some people had, and we've just seen that JRP's CDMC people were able to.
Yes, but they weren't obliged to take on the role.
No, I don't think they were
And
obliged.
I think you're telling us you understood at the time that they weren't obliged to take on the role.
Yeah, they weren't obliged.
No. No. And when you go on in the same sentence to say terminating its own appointment without ensuring a principal designer was in place, appointment as what? Can you just clarify?
Its own appointment that they were the CDMC.
Yeah. But the disappearance or the end of the role of CDMC was as a consequence of the new regulations abrogating that role, wasn't it, rather than any termination by Artelia?
I think they issued an email saying we are now no longer CDMC, so they clarified via an email.
Indeed, and they had to do that because the role had disappeared by as a result of the legislation or regulation, hadn't it?
Yes.
So this wasn't a unilateral decision by Artelia to give up the contractual obligations it had as CDMC.
No, it was a formal notification.
Yes, and you understood that at the time, presumably. Yes. And they were they, obliged when their role as CDMC came to an end to become a principal designer, as I think you've accepted?
I have, but I say at the time it wasn't clear, that they weren't going to, because you appreciate they'd issued me an F10 naming themselves as principal designer,
No.
which was for the extension of time period. So it wasn't clear at all whether they were going to continue.
No. And do you accept that they were entitled, indeed obliged, to terminate their appointment or accept the termination of their appointment of CDMC without being obliged to ensure that a principal designer was in place?
I understand that they formally notified us that their CDMC appointment had ended, but it would be within their professional gift to actually advise us how to deal with the appointment going forward. Yes.
Do you recall the email I showed you earlier on about the role of the CDM compliance advisor? Remember that? That's
Yes.
We can go back to it if you like. It's the email of the 25th of September where Simon Cash records the call that you had with him that day.
Yes.
Do you remember that Artelia offered to provide a CDMA service?
Yes.
Yes. And did you discuss that role with Simon Cash?
I don't remember.
You don't remember?
No.
Do you recall why that role wasn't taken up by the TMO? Or rather, why that role wasn't accepted by the TMO as something that Artelia could perform?
Yeah. Sorry, what was that?
Yes, it was a bad question. I'll rephrase it. Do you remember why it was that Artelia didn't take on the role of CDM compliance advisor to you?
I think because at the time that I spoke to Simon Cash, that he mentioned about the scheme, one option being if the scheme is fundamentally complete.
Right.
So that seemed to be another option. I was probably a little bit wary at that time because there had been a commitment from them earlier to give me a bundle of papers from the CDMC to whoever it may be,
Right.
taking on the PD role, and that bundle of papers transpired to be nothing more than the original tender paperwork.
Yes. I mean, in the light of the fact that Artelia had offered to provide the CDMA role to you, and in the light of the fact that it was really required by the legislation to give up its CDMC role, I wonder whether on reflection, your criticism of Artelia in paragraph 26 is really justified.
Sorry, can you say that again?
Yes. In light of the fact, as you've accepted, that Artelia had offered to provide the CDMA role to you,
Yes.
which you refused, and in light also of the fact that their termination of their CDMC role was one required by the legislation, and your acceptance of that, I wonder, in the light of that, whether you might accept that your criticism of Artelia in paragraph 26 of your statement here is really justified.
I think the conversation in which Simon Cash went through some of those options was very late in the day. It would have been useful to have had that conversation probably in the April. I think many of my comments about the CDMC role do relate to the fact that it started off obviously at pre-construction, and I would have liked a little bit more activity during the scheme, or a little bit more contact. And I think it is something that many people do. They ring as a courtesy or whatever. But I don't think I knew when Keith Bushell, for example, left their organisation. So I was a little bit sort of left in the dark as to what they were doing, and felt that their engagement was not as perhaps as rigorous as it could be.
Can we then turn to the question of the design being fundamentally complete, which is a phrase I think you've used and that some of the documents use. Can we start with ART 404824, please? This is an email chain between you and Neil Reid in early October 2015. And can we go to page 2, please? And on page 2, we can see an email from you, Miss Williams, to Neil Reid on the 1st of October 2015. And you say, "Hi, I was just thinking about a catch-up with you too." And then you say, "My top issues are," and you can see, just noting it, Ryden Resources. I'm still not convinced that Ryden have enough resource to manage the scheme to an end. And then 5, CDM regulations. As long as the project team agree the design is fundamentally complete, then we believe the provisions within the legislation allow KCTMO to request a principal contractor to compile the H&S file and issue direct without the formal appointment of a principal designer. Can we get this put into the meeting next week and check that the team agree the design is, quotes, fundamentally complete, close quotes, and get this minuted? I think that's it. Catch up maybe Friday as you suggest. Do we take it from that you knew that a key duty of the principal designer was to compile the health and safety file?
Yes.
And by early October 2015, about a week after hearing about the principal designer role and discussing it with Simon Cash, as we can see, you are here making a plan to ask the principal contractor to compile the health and safety file. Is that right?
Yes, I think, was I not paraphrasing what Paul Burrows had told me earlier?
Well, you tell me.
I suspect I was getting information from different parts of our atelier that I was putting together.
Now, in your 20th of January 2020 witness statement, you say that it was Simon Cash who used the term fundamentally complete. That's paragraph 21 if you need to look at it. Do you remember that it was his expression?
I think he was the person who I was speaking to at the time, so that's not a phrase I would use, so I believe it came from him, yes.
I see. And indeed, you can see in paragraph 5 of the email that you've put the words fundamentally complete. In the second occasion, you use it in inverted commas. Is that because it wasn't your phrase, but his phrase?
Yes, it seemed to me to be a sort of a legalese phrase to cover it.
A legalese phrase? What do you mean by?
Something that would be recognised at a date saying this is why this decision was made.
Did you think it was a formal expression that came from the regulation?
Possibly. That's.
Did you check?
No, I didn't check.
Right. You also say in that same statement, and again, Ms. Williams, we can look at it if you like, that had further design work arisen, you would have undoubtedly referred to Ryden. Is that right?
Sorry, why are you saying that?
Well, let's take you to it. If we can go to your 20th of January 2020 witness statement, TMO 00853 please, and look at page 6. I'd look with you at paragraph 27. You say there in the third line, had further design work arisen in the period between the TMO's appointment as principal designer and the completion of the project, this would undoubtedly have been referred to Ryden and the professional team. You see that?
Yes.
Now, compiling a health and safety file is a separate issue to signing off new design, isn't it?
Yes.
And at the time of the regulation change, is this right, that the main outstanding task was to compile a health and safety file?
Yes.
In other words, outside design, the principal designer still had a very significant duty to fulfill with the health and safety file.
Yes.
Yeah. And do you think you should have paid more attention to who was equipped to fulfill that task, namely compiling the health and safety file?
At the time, I believed we were going to get some good information from our atelier CDMC, which would help with that role.
What was the good information that you were expecting?
They'd early on issued to all parties a document to be completed, and they'd given some guidelines as to what they would expect in that. So I was expecting to see at least that started, if not completed.
Right. Is that the handover pack?
I don't know, I never saw it. So
Oh, I see.
that's
Okay, well,
what I'm saying, that they led me to believe they had something to hand over, which would have been very useful to the principal designer role. But in fact, what was handed over was the information that was delivered pretty much at tender.
Indeed. Well, let's see how we go with this. If you go back to ART 404824, which was the email run we were looking at, this is his response to you from Neil Reed on the 2nd of October 2015. Quick sit rep, which I think is situation report. Is that right? On the belay before we speak later. And then if you go down to item 5, CDM, I think this needs to be your call, Claire. Re-1, the design sufficiently complete. Re the H&S file, it does leave the question as to who then checks the file and confirms it is compliant. Would you like Artelia to provide a due diligence role in this regard to ensure the file complies with the ERs and the CDM regulations, as I think we may be able to provide a CDM advisor type role as opposed to the PD role? Now, did you read that as an explanation of what a CDM advisor would do for you in these exact circumstances? Namely, check the health and safety file.
I think that's the clear explanation of what the role would entail.
Exactly. And here we see Mr Reid specifically raising the point that if the TMO took on the role, there would be a question as to whether the file, as delivered by Ryden, was compliant with legislation. Do you accept that?
Yes, that's what he said.
Yes. Now, ultimately, the TMO decided not to appoint a CDM advisor, as we know,
Yes.
and you've confirmed. And was the reason that the design was fundamentally complete?
Yes, I was, when talking to Simon Cash, one of the options that he said was if it is fundamentally complete and no design decisions are outstanding, the outstanding role would be compilation of the health and safety file.
On which I would suggest to you it would have been extremely helpful to have a CDM advisor, precisely for the reasons that Mr Reid points out in this email at paragraph 5. No?
I was expecting to have a starting point on the health and safety file. I wasn't expecting to be given nothing. I was expecting to be given something quite clear which would direct what they would expect in it in terms of the ERs and the CDM regulations.
You see, what I'm really getting at is, although the design may have been fundamentally complete, the health and safety file work, which was part of the principal designer's role, needed to be done properly. Here you have Artelia offering to do that role, but you reject it. Why did you reject it?
I was expecting, when their role terminated, that they gave me a handover pack which had at least the skeleton of a health and safety file and some initial information in it. But, as I say, nothing was forthcoming. So I was expecting that there would be a starting point from Artelia.
But a starting point from Artelia wouldn't have been equivalent to a check, a confirmation of compliance in the performance of a due diligence role to make sure that the TMO, as principal designer, fulfilled its statutory obligations. Would it?
It wouldn't be a CDMA role, but say if I had the health and safety file that they'd got away in preparing, that it was more than just a standard template, that would have been something that could have been easily continued with.
Had you ever put together a health and safety file for the purposes of regulatory compliance on a project?
No.
No. So this was the first time that you had to do it.
Yes.
And given that you're being offered here a professional due diligence role to make sure that you, in this new role, complied with this new statutory obligation, why didn't you take them up on the offer?
Because, as I say, I thought they would have given me as their handover enough information to be able to do it easily.
So do it yourself?
Well, obviously the principal contractor would be providing most of the information, but in terms of finalising it, yes.
But what gave you the confidence that you could do it yourself, as opposed to putting it safely in the hands of Artelia, who are offering you a professional service for the purpose?
As I say, I thought I was going to get something from them which was more than just an empty template. I was expecting to get some information from them in terms of perhaps it complies with the ERs, it could be a checklist, it could be something of that sort.
But it wouldn't be advice about compliance, would it?
I suspect that they would have more information as to what compliance would mean. So that I would expect to be at least in the health and safety file handover I was expecting.
The truth is, Ms. Williams, that you were offered a golden opportunity to get this right and you turned it down.
We didn't take up the offer of the CDMA.
Well, that's how you put it, but is the answer to my question yes?
You said we got it wrong.
Well,
I
said
what
you were
wrong
offered a
means.
golden opportunity to get this right and you turned it down.
We did not take up the CDM advisor role.
Indeed. Can we then go to the minutes of the next progress meeting on the 17th of November 2015 at ART 405184, please? This is progress meeting number 17 of the 17th of November 2015, as you can see. And again, Ms. Williams, you're there, identified as the third person present on the list on the left. And Neil Reid is in the chair, if you note just below the bottom of the page. And if we go to page 2, we can see that the issue of CDM regulations is picked up at item 2.8. You see that? At the bottom of the page. Item 3.2, it says, as part of it starts at 2.8 and it's item 3.2, CDM regulations 2015, AM noted the PMN on the previous minutes, copied here for completeness. Now these were those that we saw earlier on, Miss Williams. Do you remember? And we read it again,
Yes.
because it's there. PMN under the 2015 regulations. If the PD appointment finishes before the end of the works, then the principal contractor takes on the PD role. This means the principal contractor puts together the H&S file for the client for discussion at the next progress meeting. And now we come to the next progress meeting, which is this meeting, and here we see what's minuted. It was agreed that Ryden are not the PD, principal designer, under the CDM regulations 2015. The TMO, as the client, are to undertake this role. You see that?
Yes.
And over the page, the minute continues, it was further agreed that Ryden would be responsible for collating and presenting the H&S file information in accordance with the employer's requirements and the PCI, and present it to the TMO as PD. Now, the words present to the TMO as PD, did that mean that the TMO was to be the principal designer, at least in name?
Yes.
And what was your understanding of what Ryden would actually do?
They would have information that would be required. I think we're calling it the health and safety file information, but I also think it's the O&M manual. So they would normally have all the information on, they would have the as-built drawings, they would have information on service runs, that sort of thing. So they would be presenting it to the TMO to put together. But I think we've called it health and safety file information. I suspect there's actually a health and safety file and the O&M manual.
Right. Was there any discussion of what you've just told us, namely the O&M manual, so the information including as-built drawings, etc.? Was there any discussion of that at this meeting?
I don't think so. I think this was just the headline. I don't think we delved any more into what was contained.
Right. Was there any discussion of any involvement of anybody else on the project team in assisting Ryden to collate and present the H&S file?
I don't remember there being any.
Can we take a step to the side for a moment and look at the approved code of practice for the 2015 regulations? This is HSE 703. It's also called L153. Do you recognise this document?
No.
You've never seen it before?
I don't remember seeing it before.
I see. Can we look at page 81 and bearing in mind what you've told us that you hadn't seen it before, let's see how we go. But let's see the obligations, or at least the guidance about them. This is Appendix 4, the health and safety file. And at paragraph 1 it says, this appendix gives guidance on the preparation, provision and retention of a health and safety file and the actions on each duty holder. Appendix 5 shows how the health and safety file relates to and influences other types of information during a construction project involving more than one contractor. And then there's a question, what is the health and safety file? The health and safety file is defined as the file appropriate to the characteristics of the project, containing relevant health and safety information to be taken into account during any subsequent project. The file is only required for projects involving more than one contractor. And then it tells you what it must contain under paragraph 3. The file must contain information about the current project likely to be needed to ensure health and safety during any subsequent work, such as maintenance, cleaning, refurbishment or demolition. When preparing the health and safety file, information on the following should be considered for inclusion. And then there's a long list, A to H, about what should be in there. We can look at the details if you like. But if you look at the list, there is matters such as hazardous materials, as under D, and under H, information and as-built drawings of the building, plant and equipment, for example, the means of safe access to and from service voids and fire doors. And then 4, first sentence says, there should be enough detail to allow the likely risks to be identified and addressed by those carrying out the work. However, the level of detail should be proportionate to the risks. I know you say you weren't familiar with this document, but were you familiar with at least these principles about what the health and safety file was and what it should contain?
Yes.
How did you become familiar with those matters?
I had training, so I suspect it was in some of the notes I had as bullet points.
Right. So the training that you had didn't include your having sight of this document, is that right?
That it would have been referred to, but I don't think a trainer would have given out an 81-page document.
Right.
So.
Did you think at the time that you, in particular, Miss Williams, would be qualified to assess the health and safety file presented to you by Ryden as compliant with the regulations?
Well, that's why I say I was expecting to get something from Artelier's CDMC, which would have been a guide.
Right. That would have been a guide, but it wouldn't have been advice on what was actually presented.
No, but I think also, bear in mind, this project is different because we're doing part of the building is new build, the rest of the building is an existing building. So this was quite an unusual situation because the health and safety file would only, from Ryden, would only contain the elements that they'd been working on.
Going back to my question, I asked you, did you think at the time that you in particular would be qualified to assess the health and safety file presented to you by Ryden as compliant? And you said you were expecting a guide. My question was actually about your qualifications. Did you think you would be qualified particularly to be able to assess the health and safety file for compliance?
If I had a guide along these lines, I would expect to be able to manage that, yeah.
Right. Did you or did anybody else at the TMO consider whether anybody else at the TMO was better qualified to assess the health and safety file for compliance with the regulations?
I don't think we did, but I say this was probably an unusual setting, both in terms of the project and in terms of the change of regulations.
How would you know if the file was complete, unless you were qualified either formally or by experience?
Well, that's why I was saying that I was aware of these bullet points, but I was also expecting to get something from Artelier, which would have been more informative as to if there was any additional information or any caveats on anything or what they would want. But I think it was an unusual situation. We had the change of regs and we had, this unusual situation with the building.
Did you ever get the guide from Artelier that would have assisted you, you say, in assessing compliance of the health and safety file when produced by Ryden?
No, as I say, all we got from them in the handover bundle was their document at early stage asking various parties to complete their information. They hadn't actually had that filled in, but I obviously didn't know that at that point. I was expecting something. So what I got from them wasn't actually a guide, but I didn't find that out till after the regulations had changed.
Did you ever spell out to them in clear terms, well, we don't want a CDM advisor, thank you, but we would like very much, please, a written guide for us so that we can tick it off when assessing the question of whether or not the health and safety file compiled by Ryden complied with the regulation?
No, I didn't ask them specifically. They probably would have referred me to this documentation.
Well, whether they probably would have or probably wouldn't have done. I take it you didn't.
But I didn't ask that specific question.
No, so why is that?
Because I think they were very clear about their roles. We've seen several emails the last few days about what they will do and what they won't do within their role. In fact, they were a little bit, in my view, slow off the mark to inform us as how to manage the PED role with the change of regulations. I didn't have any reason to think that a conversation of that sort would be fruitful.
Right. Did there come a time when you ever asked yourself, well, I wonder where the guide, the helpful guide for the health and safety file has got to?
I did. I think I chased Andrew Malcolm because I think there was reference a couple of times when I think eventually I met Paul Burrows. He said, oh, yes, I'll get across to you what we've got. Great. But then, say, it transpired not to be of any substance in terms of taking the scheme forward. It seemed to have stopped pretty much at tender stage.
And at what point did it appear to you to lack the substance you were expecting?
When I saw it, or when I saw what Paul had when I'd asked the question, because, as I say, there had been earlier, oh, we'll pass you what we've got, that's fine. So I was expecting something.
And when was
I didn't
that?
get. I don't remember. Right. Obviously, we've looked at conversations July, September time, haven't we? So.
And at that point, do you remember feeling disappointed and thinking, this isn't what I was expecting, I need more?
Yes, I was led to believe it was a handover bundle. I was expecting something more substantial.
And when you saw it wasn't as substantial as you were expecting, did you ask Artelia for the substance that you were expecting?
I think I would have said to them verbally. I don't know that I followed it up, because by that point they notified that they were terminating their appointment. I think they were feeling that area of their work was complete.
Did it occur to you perhaps to go back to them and say, well, after all, we'd like you to be our CDM advisor?
No, I think perhaps by then my confidence was a little bit iffy, but no, we didn't go back to them and ask them.
Can we go to ART? Mr. Chapman, I'm sorry, you may have had a...
No, I'm sorry, I asked my question, I shouldn't.
No, that's fine. Can we go to ART 409364, please? Now, this is an email from Paul Burrows to you on the 9th of November 2015. And it says, in the subject line, do you see CDM advisor?
Yes.
Dear Claire, further to our discussion on Friday and the handover of CDM information for the Grenfell project, I can confirm that there is no legal requirement for a CDM advisor. And just pausing there, do you remember the discussion on the Friday, presumably the previous Friday, that he was referring to there?
No, I don't remember it.
Do you remember the handover of CDM information for the Grenfell Tower project that he's referring to there?
Don't remember whether he just emailed me the bits and pieces he had.
I'm not suggesting that there was a face-to-face meeting,
Yeah.
but he refers to a discussion and he refers to a handover. You can't recall the discussion. What can you tell us about the handover?
Yeah, no, that's the point at which I believe he just sent me the stuff that had been on the table since tender.
I see. So at this point, you'd had the handover of CDM information that you were expecting from Artelia.
Yeah.
And then he goes on to say there's no legal requirement for a CDM advisor. And he confirms that that is the case.
Yes.
Was he confirming to you that that was the case because you had asked him the question?
I would expect, I would read it so, yes.
Right. Why were you interested to know whether there was a legal requirement for a CDM advisor?
I know that they had offered that, but again, I wasn't clear on the status of that, and he's obviously said there's no legal requirement.
Did you ask him the question because the fact that there might have been a legal requirement might have made a difference to whether or not the TMO decided to appoint a CDM advisor?
I asked him because, say, I wasn't familiar enough with the regulations, whether a CDMA was in lieu of another role or whether it was a statutory position. So it was clarification to make sure I understood that there was no appointment we needed to make legally and to get some advice.
It looks on the basis of what you've said so far about the discussions between September and now, that you had been offered the CDM advisor role, had turned it down because design was fundamentally complete, but were now asking whether there was a legal requirement to have one. Do we take from that that you didn't want to have one unless you were required to by law?
I think I was trying to understand the regulations more. We were in an unusual situation, I felt, because our project it crossed over between the old and the new regs. And so I was just trying to understand and get advice from him as to what it was. And I see he's put here in the penultimate paragraph that a number of people do use a CMA advisor role. So he's just giving me more background information, but as he said, there is no legal requirement.
Macy, I know all that, but I'm just trying to pin you down, if I may, on precisely what it was that drove you to ask the question, is there a legal requirement, which he's answering. And I'm suggesting to you that what was driving it was the decision you'd already made not to have one, but you were concerned that by not having one, you might infringe the regulation.
Yeah, I wouldn't want to infringe the regulations, and I don't remember talking to Simon Cash about whether it was a statutory role or not. So obviously he's just filled the gap.
And do we take from that, in short, it's a simple point, you didn't want one unless you had to have one?
I think if I knew whether we needed one or not, that would then inform the decision.
Thank you. And then we go on with the rest of the email. He lists below, where we've just been looking at, the 5 duty holders there, and then goes on to say a number of local authorities and private organisations are utilising a CDM advisor role to ensure that either they or organisations they have appointed are working in compliance with the regulations. But I can confirm that there is no legal requirement for this. If at any point in time you feel a service such as this would be of benefit to KCTMO, please contact me, as this is something we can provide, but I stress that there is no legal requirement. Now, at this point, you've had the handover of the CDM information. Did you consider whether it was adequate for you to perform the role of principal designer in relation to the health and safety file that you've told us you understood, looking at the code of practice we looked at?
So, as you say, I've seen the information he provided on the CDM, which, was limited. And I was looking at whether a CDM post was required. Sorry, will you go and ask me your question again? I'm just trying to absorb the information.
Yes, of course. At this point, the CDM information has been handed over to you. You told us you were expecting a guide which would enable you to check compliance of what was ultimately handed to Ryden. I'm assuming that after this email you studied, or at the time of this email, you studied the CDM information that you got from Artelia.
Yeah.
Yes?
Yes.
Did you form a view at that stage whether it was adequate to assist you in assessing whether or not Ryden were going to comply?
That's many questions, many parts. So at the moment, you're saying I've got the CDM information from them, which I am saying was very limited. You're asking me whether Ryden were going to comply. That's a slightly different question.
No. Let's break it down. The email comes on the 9th of November. It refers to a handover of CDM information. Did you look at that CDM information?
Yes.
Did it satisfy you that it was sufficient to enable you to assess whether, when Ryden produced the health and safety file, it would comply with the regulations?
I cannot at this stage say what Ryden are going to hand me to comply with the regulations. I can see that I've got limited CDM information from Artelia, but I don't know what Ryden are going to deliver to me, so I can't tell. Sorry, it's just the way the question was phrased. I think you're asking me if I'm going to be able to tell what Ryden hand me will comply. Well, at that stage, I don't know that I'd actually thought what Ryden were going to hand me.
No, I'm quite sure that that's the case, Miss Williams. And it may be my fault, but trying to encapsulate the evidence you gave us earlier this afternoon, you refused the CDM advisor role because you were going to get a guide
Yes.
from Artelia that would help you assess whether Ryden, when it came to produce the health and safety file, had complied with the regulations. Now, that's what I understood by your evidence earlier. Am I wrong about that?
Whether the information Ryden gave me would comply with the regulations. Yes. No, sorry, I'm just trying to understand your question because...
Well, let me try it a totally different way. I'd understood your evidence so far this afternoon that what Artelia were going to give you was a roadmap, a
Yes.
guide, so that you could hold it in your hand
Yes.
and then tick off the boxes to make sure that when Ryden did produce the health and safety file, you could satisfy yourselves that they were
Yes.
compliant. Yes?
Yes, as you say, I expected a roadmap partially completed
Yes.
to give me guidance.
Yes. Now, when you got the handover of CDM information to which this email refers, on the Friday before the 9th of November 2015, was that the roadmap you were expecting?
No, it didn't have enough information in it.
Right. Did you then go back to Paul Burrows and say, your handover of CDM information is inadequate and insufficient for me to be able to perform the PD role? Can you do better?
No,
Why not?
because I thought it had been a struggle with them so far, and I wasn't clear that I was going to get much further.
So did you ever ask Artelia to do better and produce the roadmap that you expected from them?
I think I had conversations that I was unhappy with their performance on this element of work.
Does that tell us that you never got the roadmap you were after and were therefore completely unequipped to be able to assess what Ryden eventually produced to ensure that it complied with, or enabled you to comply with, the CDM regulations 2015?
What I did have was a template. I had somebody from Ryden compiling the health and safety file, but can I point out the issue with our building was that we had an existing part of the building that Ryden were not involved with. They were not involved with water tanks in the roof. They were not involved with several, let me just think. There was areas of the building that were existing, so whatever Ryden provided would only be partial information in terms of the health and safety file. Because Ryden, for example, wouldn't know about our emergency lighting testing, which was done as a servicing contract on the building. That wasn't in their remit. So Ryden were never going to provide complete information for that health and safety file. I think that's quite important to mention because the building contract, as I say, only covered elements of the building. It didn't cover the whole building. So Ryden could never give total information for the health and safety file because they were only involved with certain areas.
Right.
So that's possibly a complication, but I think that's quite important to understand.
Well, where would the information come from to enable you to be able to have a complete health and safety file?
That would be held on TMO systems like Keystone we've talked about, where there would be information, say, on asbestos, because Ryden only did asbestos removals in flats where they had to, where they were working on, say, the new heating system or something of that sort. So the TMO was still doing asbestos removals in other flats. Say we found an empty, a void, somebody had moved out, new person moved in, we would have had an asbestos check done at that point. That would never have been in Ryden's health and safety file because it's TMO commissioned.
So when Ryden took on the role of compiling the health and safety file, did you understand that they would be taking on a role in relation to parts of the building with which they had had absolutely no relationship?
They could only do the health and safety file on areas of the building that they were contractually involved with. So, for example, they didn't touch the water tanks in the loft. They didn't do anything to the lift motor, which the TMO would have had serviced as part of the ongoing maintenance contracts.
So when you instructed Ryden to produce the health and safety file, that was a limited instruction, was it? only in relation to the matters
Yes.
concerning the project in respect of which they were the contractor.
Exactly.
And the rest of the health and safety file would have come from the TMO, would it?
Yes, that's it.
Right. Now, looking at the contents of the health and safety file itself, what involvement did you have in the compilation of it?
What happened was that Ryden employed a company to collate their information, and I met with the chap, Steve, and he gave me a framework of what he was going to produce. And so basically I waited for him to fulfill what he said he was going to do.
Excuse, Mr. Miller, have we finished with the document currently on the screen?
Well, I'm not... possibly. Now, I think now not. There may be a question you have.
Well, I've already asked it once, but I asked it in ignorance of this document.
Yes.
But the question to which I would welcome an answer, and Miss Williams' assistance, is this. You had received, by the time this email was received,
Yeah.
you'd received the pack from Artelia,
Yes.
which did not contain all the information that you were hoping to receive to enable you to compile or oversee the compilation of the health and safety file.
Yes.
You were told that it wasn't a legal requirement to have a CDM advisor,
Yes.
but as we can see from the last two paragraphs, it was made clear to you that a lot of local authorities and other organisations were using a CDM advisor to ensure that they were working in compliance with the regulations.
Yes.
And from your point of view, that might have been particularly important if Ryden weren't able to provide you with all the material required for the health and safety file, as you've just explained.
Yes.
They then go on to say, if you'd like to have the benefit of that service, they'd be pleased, Artelia would be pleased to provide it. Why did you not at that stage ask them to provide it?
As I say, I think by that point I probably lost a bit of confidence in their service. That would be the main reason.
All right, thank you.
Right. Well, I was going to come...
Well, I'm sorry if
back-
I've
back
stolen
to this.
your next question, but three, but
No, no, that's okay. In the light of what you've just said about Ryden only having a partial familiarity with the matters that would go into the health and safety file, and now looking back at this document, particularly in the penultimate paragraph and the last paragraph, given that it was to be a patchwork document compiled from different sources, wasn't it particularly important for the TMO to have somebody look at the whole thing, such as Artelia, providing the services of a CDMA to make sure that it all complied with the regulations?
The thing about a health and safety file is it's a live document. It's not something you put to one side and think, oh, I won't look at that for 10 years. It's a document that gets updated, containing elements of where the service runs are, about hazards, about cleaning materials, things like that. Those will change. They will change annually. They could change 6 monthly in some areas of the building. So what you're looking at now as a health and safety file will be different in 6 months' time and a year's time, because the building will have had, say, areas rewired. It will have had more asbestos taken out of it. So it's not something that's set in stone. It's something that, say, is updated as works are done to the building. So having a CDMA advisor look at it would not help in that area, because, as I say, it's a live document. It's something you change as you do different works on the building. So and that's why, say, the TMO, for example, would keep stuff on a database, because then you can update it. It's not something you would print off. It would be a massive document.
Well, I can understand that it's a document that requires updating from time to time, but given that it was a document, a file, namely a single collection of material that Ryden would collate and present, why not have the CDM advisor assess that document, which existed at that particular moment in time?
because it would be partial in terms of the Ryden information, and it doesn't mean that they would look at the whole of the building, which is what the health and safety file would need to cover, the whole of the building. So getting them to look at part of the information, which would be potentially changing, that doesn't, to me, seem to be a valuable option.
Did you understand precisely what it was that had to be compiled at the end of the refurbishment project by way of the health and safety file?
Using the bullet points we saw before as a checklist, that was what I would expect to be in the health and safety file, yes.
Yeah. And therefore, what was the problem with getting a CDM advisor to look at the document which was supposed to contain all the bullet points at that point and advise you whether it met the obligations under the regulations?
But the Ryden information on its own would probably not meet the regulations because it was so partial. I would expect the health and safety file to cover the whole building, not just the lower ground floors, for example.
Right. So, and we're going round in circles a bit here, so I'm going to ask it one more time. Having got the health and safety file, which contains the Ryden bit and the rest of the building bit, as a single document, given the fact that it was a patchwork, why couldn't you ask the CDM advisor to look at it and advise you whether that file, including Ryden's part, complied?
Yes, I'm sure they could do it, but my suspicion would be that they would use the checklist we have just seen, the bullet point checklist, but also there would be a lot of information from within the TMO that would take a reasonable amount of time to collate. It would be something more sort of a policy type role as to whether the information we held on our TMO database was appropriate for the health and safety file, I think.
Did anybody at the TMO turn their minds to what was needed from the non-Ryden part of the health and safety file to make sure that all that information was collated and given to the person collating the file as a whole?
No, we never looked at putting the two parts together, to my knowledge.
Right, so does that tell us that you never looked to putting together a single complete health and safety file?
No, we didn't, because, as I say, the health and safety file is something that would be updated. Even from 1 month to the next, we may have done more asbestos work in the existing occupied parts of the building.
Right. Just focusing on the Ryden part then, David Hughes of Ryden told us that he had had meetings with an organisation called All Group Holdings in respect of the health and safety file. Were you at those meetings?
No, but that was the chap, Steve, I met, came from that company.
Yes. Yes, but were you at those meetings?
Not with Dave, I don't think, no.
With anybody at All Group Holdings? Did you ever have a meeting with All Group Holdings?
Yes, I met Steve, I think, 2 or 3 times.
Right. Did you monitor the gathering of the information for the health and safety file, or at least that part of it for which Ryden was responsible?
That there was All Good were, I think this is what their role was. They did this day in, day out. They did do health and safety files. They had a number of headings, and so they were due to complete or get from Ryden all the paperwork within those headings. So that was what I was looking at initially.
What steps did you take to satisfy yourself that the health and safety file, when it was presented to you, was a complete file?
I believe that we had several interim, I know we had several interim meetings where I was asking, where's this, where's that? And essentially I was just making sure that everything that Ryden had would be what would be in a health and safety file. So when you say monitoring, I was checking against the headings I had.
Which you weren't satisfied with?
That there were gaps, and I think there was quite a bit of toing and froing.
Now, do you know that the inquiry has two different versions of the health and safety file, one from Ryden and one from the TMO? Did you know that?
No.
Right. Now, the Ryden version has a section 4 health and safety file, but that section contains no information, whereas the TMO version contains an index, which we're going to look at in a moment. Did you know that?
No.
Right. Would I be right in thinking that the one that the TMO has disclosed to the inquiry would be the one that you would have considered to have been the final and complete health and safety file?
I don't know. I haven't seen them. So.
Well, let's look at it. It's TMO 10013708. This is the contents page of the health and safety file. It's page 1, and it is indeed an introduction, record of issue, and you can see that,
Yes.
and it lists a whole load of contents. Is this familiar to you?
Yes, I've seen this.
It is. And you can see that it's built of cross-references to the building manual. Do you see? I mean, for example, under architectural design B1, architects as-built drawings, please refer to the drawings located in the building manual, part 2.
Okay.
PCI information, please refer to the information located in the building manual, and so on and so forth down the page. You see that?
Yes.
Now, let's just look at that. If you look at B1, let's try that one, you can see that it says, please refer to the drawings located in the building manual, part 2, section 2122. And if we look at that, that's a TMOM 601. Sorry, 701. I'm so sorry, 701. TMOM 701. And we turn to page 2. We can see the contents page of that. And if we go to page 9 in that document, we can see that there is a 2.1.2 and a 2.1.2.1 demolition drawings, but no section 2.1.2.2. Can you explain?
No.
Can you explain why the references in the health and safety file are to the building manual?
No.
Did you check this at all?
I did.
Did you check it thoroughly?
I checked it and there were deficiencies.
Was this one of the deficiencies you identified?
Yes.
What did you do about that?
Went back to Steve to point that out.
What did he do about it?
He did add in more information, but I don't know if this is the final one.
Well, this is the only one we've got disclosed by the TMO.
Okay.
Can you explain why it doesn't have the information that you say you went back to Steve and asked for, and he gave you?
No.
Did you really see this through, this job?
Yes, I did.
Can you explain how, having seen it through and got the information, the document lacks the detail I've just been identifying?
I think that Steve went back to Ryden, and I don't know whether he got all the drawings that he'd asked for. It looks as though he didn't.
Mr. Chairman, I've got about 2 more questions or 3 more questions on this topic, and then one final short topic. Can I continue on this topic?
I think the witness ought to have a break before too long. But how long do you think it might take you?
5 minutes to finish this topic, and then maybe 10 minutes on the next topic.
Well, should we finish this topic and then
Yes.
perhaps have a break?
Yes.
Is that right, Ms. Williams?
Yes, that's fine, thank you.
Okay.
Can we go to ART 405362, please? This is the set of progress meeting minutes number 20 on the 23rd of February 2016, and you're their third attendee down, as we can see. And if we can go to page 4, please. I'd like to go to item 220. And at item 220, you can see next to item 3.10.2, fire compartmentation action update, it says, SB met with Carl Stokes, fire risk assessor, advised Ryden not to introduce or alter any further fire protection works, and nothing further is to be progressed other than the remedial works required of the COW in relation to Ryden's own works. CW to liaise with Carl and confirm that this is indeed the case. Carl Stokes will produce a report in the form of the fire risk assessment, identifying any shortfalls, which will be submitted to CW on or near completion. NR requested that this be included in the HNS file, CDM, on completion as formal recognition of a fire risk shortfall and potential residual risk arising from the building in its previous form. Was the health and safety file updated to include any such report, Ms. Williams?
I don't even know what that topic is, so I'm not sure.
Well, you were at the meeting, as we've just established.
Yeah, no, it doesn't actually specify anything, does it? It says introduce of any further fire protection works. I'm not clear what that's to, where that is in the building.
Well, this is an action update. Item 220, fire compartmentation action update, and you are the person who is going to action this, and then SB is going to be actioning the inclusion in the health and safety file. Is SB the Steve you're talking about?
No, that would be Steve Blake, I assume.
Steve Blake,
That would
right.
be Ryden.
Very good. So these are two action points. What was the discussion that you can recall about the fire risk assessment, which identified shortfalls to be submitted to you, then being included in the health and safety file? Do you remember a discussion about that?
I don't remember what this is about. If there is any information which will give me a clue, it would be useful.
Well, you have no memory of this meeting, I think, and you have no you can't assist us on its record.
I don't remember this particular area, and because it's not specifying where it is or what it's about, I'm afraid it doesn't ring any bells.
Right. Well, did the health and safety file, in its complete form, include, on completion, a report from Carl Stokes recognising a fire risk shortfall and potential residual risk arising from the building in its previous form?
There would have been a fire risk assessment with it, but I'm not sure what this particular bullet point is about, because it says that I'm going to confirm that this is indeed the case. So it's not quite clear to me whether that the point as raised is closed out.
Well, did you, taking it in stages, did you liaise with Carl Stokes to confirm that Ryden was not to introduce any or alter any further fire protection works, etc.?
I don't remember. If I knew what element of the building you were talking about, then I would be better able to answer. But
Well, you see, Ms. Williams, I'm just asking you about this minute. I wasn't there and you were at the meeting, and I'm just asking you what it all means, you see, because this is a written record at the time of a meeting you were at, and I'm just not there. So I can't help you with that. But it sounds to me as if you simply can't help me at all with the contents of this minute.
I don't remember what area of the building it's talking about, whether Carl did confirm it was the case, and therefore whether there was anything in the health and safety file.
Right. Mr. Chairman, is that a convenient moment?
Yes, I think it is. Just for everyone's benefit, can you give us any rough idea of how much longer you will need? Not that it matters, it's just that...
I can. I have one short topic to cover, then I have a miscellany of follow-up points from last night and this morning, which are about 10 minutes.
Right.
So I would think probably another 20 to 25 minutes on prepared questions. And then there may
Then
be
we've got the usual.
the usual 30-minute, yes.
All right. Thank you very much. Well, we're going to have a short break now, Miss Williams. We'll come back at 25 to 4, please. And again, please don't talk to anyone about your evidence or anything to do with it while you're away. All right? Thank you very much. Thank you. 25 to 4. Thank you. Would you ask Ms Williams to come back in, please? Thank you. Right, Ms Williams, ready to go on? Thank you very much. Yes, Mr Millett.
Thank you, Mr Chairman. Ms Williams, one more topic and then some follow-up topics. Regulation 38. Can we go to your 20th of January statement, please, at page 13? And I'd like to look at paragraph 61 and 62, please. And at 61, you say, I'm aware that regulation 38 of the building regulation requires that where building work involves the erection or extension of a relevant building, fire safety information shall be given by the person carrying out the work to the responsible person at the completion of the project. And then you say, my memory in relation to this aspect of the project is limited. However, I do recall it being discussed that Regulation 38 may not apply to the refurbishment works undertaken. My recollection was that we were advised that this was because the works only related to certain parts of the building and specific works, but were not an erection or extension. In any event, I was told that everything that needed to be passed to the TMO was passed by Ryden on the memory stick, referred to earlier as part of the O&M manual. Now, aside from any advice, I think you accept there that you knew at the time of Regulation 38 of the building regulations.
I knew what it says there, yes.
Yes. And did you know, therefore, that in particular fire safety information was to be provided to the responsible person?
Yes.
Did you realise that the TMO was a duty holder as a responsible person?
I would assume so, yes.
Did you realise that those were entirely separate duties from those under the CDM regulations?
Yes.
So separate duties from those to provide a health and safety file?
Yes.
Now, you seem to be under the impression that this was not a project to which Regulation 38 applied. Is that right?
I said there was discussion within the TMO office as to whether it did apply. But I generally think we were going to put all the fire and safety information we had into the health and safety file anyway.
Did anybody advise you that Regulation 38 did not apply to this refurbishment?
No.
Can we go to RYD 3094315, please? And the first page, we just flip back one page to see the document. That's DH5, so that's David Hughes's exhibit number 5, and the first substantive page of this is here at page 2. This is a fire risk assessment record of significant findings by Carl Stokes, and it's dated the 26th of April 2016, and I think we looked at this earlier in your evidence. Can we go to page 3 of this document? This is a set of the items and hazards, and if you look at the item with no item number, but high priority, in other words, the first item there, do you see?
Yes.
It says, when the construction stroke refurbishment work is completed on this building, all information as required by the building regulations, and this is in bold, must be handed over to the TMO by the contractors before they hand over the areas now under their control. You see that? And if you look in the next column along on the right under item 2, it says, documentation must include, and then item 2, all the Regulation 38 information as required by the building regulations. Now, can you explain how you thought that regulation did not apply when we can see here that Carl Stokes notes that compiling Regulation 38 information was a significant action to be undertaken by the TMO?
As I say, there was discussion within the office as to whether it did apply. I don't think we ever reached a solution as to whether it did or not, but it would be good practice to assume it did.
Well, your FRA, Carl Stokes, is telling you, isn't he, here, that documentation to be handed over to the TMO by the contractors must include all the Regulation 38 information. Did you understand that?
Yes, yes, and as I say, we would have erred on the safe side and assumed it did apply.
I see. So you say you assumed it did apply. And then by whom? It says Claire W. O&M manual in preparation. What does that tell us?
That I am responsible for actioning that point, and there are comments there in relation to the documentation that is asked for.
Right. What did you do to ensure that all the Regulation 38 information was collated and then handed over to the TMO by the contractors?
As it says that the O&M manual, so quite often that the two terms were used interchangeably, but the O&M manual and the health and safety file, it says, are in preparation. So it was work in progress.
Was it your view that the O&M manual would constitute all Regulation 38 information required by the building regulations?
Probably not, because the O&M manual has a slightly different emphasis.
Well, that was what I was going to put to you, but you accept that. And given that, what were you going to do to make sure that the Regulation 38 information required by the building regulations was provided to the TMO over and above what was in the O&M manual?
It would be looking at what information Ryden had produced in terms of fire safety and putting it into their health and safety file.
Now, at paragraph 62 of your 20th of January statement, as we've seen, you say you were told that everything that needed to be passed to the TMO was passed by Ryden on the memory stick. Did you understand at the time that there was or was to be a memory stick given by Ryden to the TMO which contained all the Regulation 38 information required by the building regulations?
Yes, it could have been by other media, but the memory stick was what I was told I would get. Yeah.
Did you receive the memory stick?
I did.
Did you open the memory stick?
I did.
Did you check that it had all the material which was required under Regulation 38 of the building regulations?
I think the memory stick went back a couple of times where there were clearly gaps in it.
Sorry, did you open the memory stick? You did.
I did.
Did
yes.
you check that it had all the material which was required by Regulation 38 of the building regulations?
I don't know that I did specifically when
Why?
I got it.
Why is that?
When I got it, there were still gaps. There was still information which Ryden had said they would produce separately.
Did you follow that up with Ryden?
Yes, there was a list of outstanding items that they later produced.
Did you ever get a complete set of information which comprised all the Regulation 38 information as required by the building regulations?
I'm not sure. I can't say hand on heart that I checked exactly.
In its final version, once you'd pursued Ryden for more information, did you ever do a check to make sure that all of the required sections of the Section 38 document were fully completed with relevant fire safety information in particular?
I believe that all the information Ryden had prepared and that we received was on it, but I'm mindful. No, from where I am now, no. At the time, I believed that there was all the information I was going to get from Ryden in relation to fire safety was on it.
Did you ever check to make sure that all of the required relevant fire safety information was in what you eventually had from Ryden?
I believe I had all that they had relating to fire safety in terms of the areas that they were building in. For example, the emergency lights to the main building were undertaken by the TMO. So Ryden would have given me what they had, but as I say, it's still partial TMO information, partial riding information.
Can I ask you to look, please, at BLARP 2606 at page, before we go off this page 1, I should tell you what this is. This is page 1 of Dr. Lane's Phase 2 report on Regulation 38 Fire Safety Information Main Report. And it's dated, as you can see, the 19th of May of this year, 2020. So that's what we're looking at. Let's go together to page 241, please, in this document. And let's look, please, together at section 19.3.7. First, can I ask you just in general, have you seen this document? Did the TMO or their lawyers ever show you this document between May this year and today?
I know that there was a report prepared. I don't know that I've seen the report.
Let me just put to you what she says at this paragraph. Based on my analysis above, it is my opinion that the Ryden Building Manual failed from a technical perspective to address the contractual requirements that had been set. None of the required sections was fully completed with the relevant fire safety information in accordance with the contract, and a substantial quantity of the provided content related to fire safety related systems was insufficient to assist the responsible person to operate and maintain the building with reasonable safety. Do you agree?
I don't know enough about the required sections being fully completed. I can see it's a resume, but I don't understand enough about what she's interrogated to comment on it, I'm afraid.
Right. So do I take it from that you've never actually been asked to consider her views?
No, I haven't. I haven't looked at this report, even though I was aware there was a report.
Can I then ask you a number of follow-up questions? The first relates to the drop-in sessions we were looking at or discussing earlier. Do you recall those, I think? My question is, were any samples of the proposed rain screen cladding shown to residents at any of the drop-in sessions?
No, because they were put up on the building during my time. I don't know whether a predecessor had shown samples, but during my time, the only samples were physically installed on the side of the building.
Do you recall that there was a mock-up done in the June of 2014 with samples of Reno bond, different kinds of Reno bond, provided by CEP?
Yes, that's what I'm describing.
Right.
That was put on one elevation.
Yeah, I see. But apart from that, you don't recall, is this right, any samples of the cladding material being shown to residents at drop-in sessions specifically?
Not at the drop-in sessions I heard, no.
Right. During the drop-in sessions, was any information provided to the residents about what the samples were made of? Or about what the rain screen that you had decided to adopt was made of?
I don't think it was mentioned in the drop-in sessions. I don't know if it was in any communication, if it was in any newsletters, but it wasn't mentioned in the drop-in sessions because it was, I think, the earlier TMO team had been talking to residents quite a lot about the cladding, but I think that the new team that I was part of were mindful that it would be the planners who'd be the ultimate arbiters on what we were going to choose. So I felt it might be a bit misleading to show residents options and then say, oh, by the way, you can't choose them, it'll be the planners. So one of the things we did in my tenure was to try and explain that to residents, that the TMO even didn't have any control over the finish to be chosen, it would be the planners.
Now, we discussed this morning the subject of looking for leaseholders or tenants to take part in the tender process. Now, as you were new to the TMO in 2013, September of that year, did you take any steps to familiarise yourself with the background and history of Grenfell Tower and its occupants?
I was given in my briefing pack information about a power surge that had happened earlier in that year. And I, as part of my induction, obviously had a session with the housing management team, particularly bearing in mind I was going to be dealing with Grenfell. So they told me about any issues that they had in terms of the building or anything they thought was relevant.
Right. During that induction meeting or process, or indeed at any other time, did housing management refer you to any residents' groups in particular, such as the Grenfell Tower Leaseholders Association?
I think they said there was one. Yes.
Right. Did they refer to any others?
There was the EMB, the Estate Management Board,
Yes.
which was, I think, sort of something they were involved with at the time. So that would have been it, I think.
Did you make any effort to contact the Grenfell Tower Leaseholders Association or the EMB in relation to the refurbishment?
I personally didn't at that stage because I was new. Later on, the EMB was disbanded, and I dealt with various leaseholders at Grenfell, but individually, not as a group, because there were many absentee landlords, and it was easier to deal with them individually rather than get them back from Somerset or wherever they lived.
Was one of the groups that was mentioned to you the Lancaster West Residents Association, do you think?
No, it doesn't ring bells.
No?
No.
Had you heard of the Lancaster West Residents Association during your time working on the Grenfell Tower project?
I don't remember that name.
Right.
Sorry.
Did you ask anybody who was a member of the Grenfell Tower Leaseholders Association, or indeed the EMB, to take part in the tender process?
I didn't personally, but say I was comparatively new, so I would have thought people who are more familiar with the management setting down there would have asked them if it was appropriate.
Right. You say you were comparatively new. I think you'd been at the TMO about 6 months or so, perhaps a little bit more than 6 months at the time of the tender interviews in early March 2014, hadn't you?
Yes.
Yes. So at that point, did you not think to contact the groups, the Leaseholders Association and the EMB, and find out from them whether any of their members would be willing to act to assist in the tender process?
No, I didn't. I know we did ask a local councillor and our chair, who's also a resident, but I don't remember anybody even mooting either of those groups.
Right. Let's go to TMO 00879-781, please. Now, this is a document that we got last week, dated the 4th of March 2014, and it hasn't got a title, but it's called, or the first line says, Finding Residents for the Grenfell Tower 7th March Contractor Interviews. Is this a document you're familiar with?
Yes, it's one of mine.
You compiled it, did you?
Yes.
Did you compile it on the 4th of March 2014?
I think I might have started it then, I don't know, or I might have put it together after several full starts, because I think there was quite a lot of people I tried to contact.
Now, we can see it comprises two lists. One, a list of resident leaseholders, and one, a list of tenants. And the approaches that you took in respect of each of them, do you see?
Yes.
When did you start the process of approaching each of these individuals that led to the 4th of March summary we see here?
I suspect the previous month.
Right. Do you remember when in the previous month?
No, I'm afraid not.
Do you remember whether it was before or after the 20th of February, when we saw the emails about the process?
I suspect it was probably about that date then, the 20th
Yes.
of February.
Yes, I see. Thank you. If you look down the list of resident leaseholders, you can see that flat 156 is Mr Ahmed, did not contact.
Yes.
Now, do you know why you didn't contact Mr Ahmed?
No, I think my list there is probably all the resident leaseholders. So no, I don't remember.
Did you know that he was chair of the Grenfell Tower Leaseholders Association?
No, I didn't.
You didn't? Right.
No.
Had you known that, would you have contacted him?
Probably, yes, because that would have covered a lot of bases, but...
Right. I see. Why did you have him on your list?
I'm thinking those are the resident leaseholders.
I see. So this is a full list of the resident leaseholders?
Yeah.
I follow. And he's the only one, it seems, you didn't contact. Is there a reason why?
No,
He appears to have
I
been
don't know.
singled
I
out.
don't know why I didn't, because I met him subsequently, but I don't think I met him at this point.
Right. Did you speak to or deal with Mr Ahmed in relation to the refurbishment after March 2014?
I believe I did. Yes.
In what context? Can you remember?
No, I can't remember, but I'm sure I did, because
Right.
I didn't meet him for a long, long time. I don't know if he was living there at the time, but
Right.
I did meet him.
Well, that subject may need to be revisited in due course, Ms Williams. Turning on to a different topic again, we looked this morning at the email of complaint or letter of complaint of the 30th of March 2016 that Neil Reid sent to the TMO about Ryden's work. Do you remember, we looked at that this morning,
Yes.
and you said that you were not concerned that Ryden was tempted to deliver poor workmanship or cut corners to keep the project on track or within their own budget. You said, no, that wasn't something you were aware of. Can I show you an email very shortly after the 30th of March 2016, written by David Collins? This is TMO 00846-104, please. As you can see, it's an email from David Collins, who was one of the residents, and he writes to you, copy to Ed Defan, subject Reed Grenfell Community meeting with TMO Ryden, 6th of April, so a week or so after the 30th of March, letter sent by Neil Reid to the TMO about Ryden's work. And if you look at the middle paragraph in the page, problems with the works, can you see? It says, residents discussed how RBKC Council and our landlord, the TMO, have prevented residents coming together to form a collective voice. And then discussion about the problems, and then a set of bullet points. And then if you look at the fourth bullet point down, concern at the appalling standard of work undertaken by Ryden in communal areas and inside a number of residents' properties. Looking at that, is it right that you were aware, when you received this email at the very least, about complaints and concerns about the quality of work being conducted by Ryden?
I know that this was really useful to get an understanding of residents' views. I'm aware that in relation to that first point about appalling standard of work undertaken by Ryden in communal areas, that a photograph had been taken of works in progress, i.e. not the finished work. So that was something that we were able to deal with.
Right.
Inside a number of residents' properties, what we would always do is tell us what, tell us where. We need to understand specifics. General comments do not help. And so what we had done, if we had got the specific detail, we would go and check and see what the status was and what the problem was. But as I say, I think generalised comments are hard to deal with. You need specifics. And as I say, I know in the communal area work, I'm very happy that what they were complaining about there was work in progress. They took it in the middle of the day. The people hadn't finished. And so that was properly finished. But the number of residents' properties say we would have asked for more specific details so that we could manage that.
I see. So are you telling us that with this specific, albeit generalised complaint, you knew what it was about and you followed up on it?
Some of the items we may not have known, we would have asked him for more information.
Did you enlist the services of Artelia to see if you could address together the complaints about, quotes, the appalling standard of work undertaken by Ryden, etc., to which Mr. Collins had drawn your attention?
Once we'd had specific information, we would be able to take it up through the contract, yes.
That wasn't my question. My question was whether you enlisted the services of Artelia to see if you could address those complaints.
Not at this stage, because it was not clear exactly what the issue was.
Right. And again, I think that may be a topic which I'll leave hanging for the moment, but may need to be pursued at a later date. Can I then come back to a document we looked at this morning before we took a short break, Ms. Williams, and that's an email of the 14th of June 2017. Before I put it on the screen, I just want to be fair to you. Are you all right to answer questions about it? It's a short question. I just want to give you an opportunity to
I
answer
am,
the
but
question.
please be sensitive.
Well, I will try, certainly. And if it helps, I won't show you the email, but I ought to have it on the screen, just for the record, so that other people looking at it can see what I'm asking you about. TMO 00870 please. Which is an email we looked at this morning. And it has 5 parts in it. I won't reread it to you.
No.
And my question, and just to give you a fair opportunity to deal with the point, we can see what it doesn't say, and it doesn't record anything in there about you having been assured by Simon Lawrence of Ryden that the cladding was inert and wouldn't burn. And my suggestion to you is that if you had been given that assurance, that would have been mentioned in this email. Do you accept that?
I think your question was, why didn't I express anything about the fire? I don't think it was what you just said to me. You said something a little bit different this morning.
Well, let me try the question differently. I'm just giving you an opportunity to accept that had Mr. Lawrence given you the assurance you say he gave you and Mr. Gibson, which we went through yesterday, then your first reaction on seeing the fire would have been to have recorded the assurance. And this would have been a perfect opportunity to do that. Do you accept that?
I think that we were being directed as to what information we needed to provide. So I understand what you're saying now, but I think the emphasis was on this is the information that we need to provide for whatever purpose. So, in honesty, there are other things going on.
Let's turn to a different and final topic, and I want to ask you some more questions about the DDA, and particularly David Bonnet. Now, this morning you said that you had no recollection of David Bonnet Associates or the name Bonnet at all. And I showed you the design team meeting minutes of the 22nd of October 2013, and you didn't recognise that. Do you remember that, in fact, David Bonnet Associates were retained to carry out a review of access for the disabled, or those residents in the building who were disabled, who had mobility difficulties? Do you remember that?
No, I don't know that.
Well, let's have a look at the document. It's SEA 408055, please. This is an email from somebody called Anita Bednarovitz, the 20th of August 2013, to Bruce Soanes, and she attaches a revised fee proposal, which was amended. And the fee proposal is at TMO 00855,736. This is the TMO's version of it, or rather the TMO's disclosed version of the same document, TMO 00855,736. And you can see that it's dated August 2013, and it's a fee proposal for inclusive access consultancy services to Studio E. Does this look familiar to you?
No, I don't know that I've seen this before.
Right. This fee proposal was within TMO's papers, so was this something that you didn't see when you came into the project?
No, I don't remember seeing this.
Right. Now, we know that David Bonnet or Bonnet Associates produced a Grenfell Tower access statement. That's at SEA 409496 at page 22. Is this something that you recognise? You recognise this?
No, I'm not familiar with it at all.
Can we go to TMO 00850-151? This is an email from, there are two emails on that page, from Bruce Soanes to you on Tuesday the 26th of November 2013. Subject, forward, Grenfell Access comments. Claire, I misread Bonnet's quote. They're not down to provide a report. I now recall asking them to omit it. They have kept us on our toes. I really don't want to put two WC cubicles in the boxing changing room. See below. We could probably make it work if you agree we should. You see that?
Yes.
And if you look below it, there is an email from Rachel Marshall at David Bonnet to Bruce Soanes, which he's forwarding on to you, you see, about sanitary provision for the boxing club, etc. And you can see that it's from David Bonnet Associates. Do you not remember that?
No, I'm afraid I have no recollection of this at all.
Right. Well, let's just try one more thing. Top of the page, then, page 1, you respond to Bruce Soanes and say, hi, I processed your invoice yesterday. I don't want two WC cubicles either. Me and Artelia going through tender stuff online. Claire. So it may well be, looking at that rather peremptory response, that you didn't give it this much attention. But did you read this emails chain when it came through, do you think?
No, I don't remember it at all. It looks to me as though I was concentrating on the invoice.
Well, it does look that way, and going through the tender stuff. But I'm just really trying to get to the bottom of whether David Bonnet, the name and their function, was really so alien to you as we might take from your evidence.
No, I'm not familiar with them at all. This doesn't ring any bells.
Very good. All right. Well, Mr. Chairman, I've come to the end of my prepared questions.
Yes, thank you.
And at the time, it's probably sensible if we take a break now, or the break now, for any
Do we
final
need 30
questions.
minutes again?
I would think probably not, but it's probably sensible just to be sure.
All right. Well, Miss Williams, as Mr. Millett said, he's got to the end of the questions he thinks he needs to ask you. But at this stage, we have to have a pause just to make sure that nothing's been overlooked, and also to allow others who are not in the room to suggest further questions that they might wish to have asked. Now, usually we only take 10 or 15 minutes for that purpose, but for reasons which I don't need to go into, on this occasion we're going to have a little longer. So we're going to come back at 20 to 5, and we'll see then whether there are any more questions for you.
Okay.
All right?
Thank
So would you like to go with the usher, please, and no talking about your evidence while they're out of the room, please? Right, 20 to 5 then, please. Thank you. Yes, would you ask Miss Williams to come back, please? Okay. Right, Ms Williams, well, we'll see if Mr Millett's found some more questions.
Yes, thank
Have
you,
you, Mr Millett?
Thank you, Mr. Chairman. In fact, I think all the follow-up questions that others have for you, I have absorbed and asked during the course of the last day or so, which leads me, I think, to the final question that I do wish to ask you. It's a question we ask witnesses who do have or have had specific responsibility for important areas of our inquiry. And it's this: looking back on the evidence that we've been through over the last 2.5 days or so, and looking back on all the events that have now come to mind through that process, is there anything that you think you now should have done differently?
I would have liked to have been able to evidence in document form the responses from Ryden in relation to my question about flame retardants and David's question about the materials being inert. I would have loved to have been able to present those to you because, say, that would have been substantial information for you.
Thank you very much.
Yes, thank you very much.
Ms Williams, those are all the questions I have for you. It remains for me to thank you very much for coming here and giving us your assistance. So thank you.
And
Can I express my condolences?
you certainly can.
I'm sorry I didn't pick it up before. But you appreciate I knew many people who died in the fire. And I'm glad that the inquiry is here and hopefully through your work we can get some resolution to stop tragedy like this happening again.
Well, thank you very much. Can Miss Williams be released?
Well, Mr. Chairman, and this is a slightly delicate subject, may I ask that she not be formally released until Mr. Madison gives his evidence tomorrow? That is simply for this reason, that because of the recent disclosure of Mr. Madison's notebooks during the course of yesterday, it is possible, and put it no higher than that, that there may be further questions for Miss Williams that arise out of those notebooks. And I don't think it would be right to release her to discuss her evidence or those notebooks until we as a team are satisfied and all other CPs are happy that there are no further questions for Module 1, I stress Module 1, which arise out of those notebooks. Obviously there are and may well be questions for Module 3 which arise out of them, but that's a different matter. Given that it is only a short period until tomorrow afternoon, I think, when Mr. Madison comes, it's not unreasonable to, as it were, hold Miss Williams over, if that's not inconvenient to her. But it is only...
Well, she won't need to be here.
She won't need to be here unless she's required to be here, and if she's required to be here to answer further questions, of course we will tell those representing her, or representing the TMO, that is to say, at the earliest possible opportunity.
Yeah. All right, thank you. Mr. Chair, nothing you want to say about that, is there? No, thank you. Ms Williams, I don't know how far you follow what Mr Millett was saying. As you know, we are still looking into the question of Mr Madison's notebooks, and it's just possible that something may emerge which will generate a question that we need to put to you. I think it's unlikely, but we just don't know. So what's being suggested is that rather than formally release you at this point, we keep you, as it were, on ice as a witness. The effect of that is that you mustn't talk to anyone about your evidence or anything to do with it until you are formally released. And just for clarity, that includes your lawyers. Okay. And we will let you know as soon as we possibly can whether we do need to ask you any further questions, or if we don't, and that you are then released from your affirmation.
Thank you for explaining that, because I wouldn't have understood that.
No. Well, I thought it was better really to make it clear what we're saying. So although I'm going to let you go home now, because it's been a very long day anyway, and time to end it, but and of course you won't be required to come back tomorrow, but if we need you back, we'll tell you.
No, that's thank you. Thank you for making that
And we'll
clear.
certainly tell you as well if we don't need you back, then you know that you're released from your affirmation.
That's fabulous. Thank you for letting me know.
Can I just say thank you very much for coming to give your evidence to the inquiry. I know it's been a difficult process at times, and I can well understand why. And I'm also conscious that it's taken longer than you were probably led to expect. I'm afraid that does sometimes happen, and we don't have complete control over how things go. But we're very grateful to you, and it's been very helpful to hear your evidence. So thank you very much indeed. Now, would you like to go with the usher? Thank you. Good. Thank you very much, Mr. Millett. Now, we are not sitting tomorrow morning. Is that
No,
right?
Mr. Chairman,
We're
we're-
expecting to call Mr. Madison at 2 o'clock.
That's the
Current
plan.
plan, isn't it?
That is the plan.
Yes.
And that should be made clear to all those watching, if that's possible.
Yes. Well, for those who are watching, I can confirm now that we're going to rise now. We're going to resume at 2 o'clock tomorrow, not 10 o'clock as usual.
Thank you.
Thank you very much.